Hello, landlords. On a Friday, this is one of those occasions where, because of trial, I was unable to be here on our regular Wednesday broadcast. But I'm here on a Friday. It's 4 o'clock, and I've got questions for you that have been asked, a whole bunch of questions actually, that stem from Friday, and a few more popped in afterward. I want to get to all of those questions. For those of you who are watching live, please join the chat. If you have a question, just put it in the chat. I'll be happy to answer. Today, we're talking all about that tenant, the tenant who put up a trampoline, and whether you as the landlord should be worried. And while I'm using a trampoline as one specific kind of thing that a tenant can do, there are all sorts of things that the tenant can bring onto the property that either violate your lease or give you some concern that now you've got a dangerous situation that you might have to deal with. V Gentry 83 says, I'm here too. Thank you, V Gentry 83. Glad to have you. Any questions you have, let me know. We're going to go ahead and get started with our talk and then get to questions. So again, any of you with questions in the live, leave them in the chat. I'll be happy to answer them along the way. So here we go. The first thing for you to consider, if a tenant brings a trampoline onto the property, is if your lease prohibits that trampoline, you got to issue notice. That is something you got to do. V Gentry says no trampolines, no swimming pools, no swing sets. Yeah, there's a whole list of things that you probably in your lease already exclude. And so what you need to know is, what does your lease say about these things that are potential, tools for disaster, right? Somebody's going to get hurt. Let me read off some statistics for you. Over 100,000 ER visits in the U.S. occur just because of trampolines. 100,000 every single year. This happens in America. Kids get hurt. And those statistics bear that out. 90% of that 100,000, so over 90,000 kids are the ones who are injured. And it's kids between the ages of 5 and 15. These kids are routinely the victims of trampoline injuries. And here's the thing, this isn't just happening, this isn't even primarily happening at trampoline parks. You're actually safer there. Most of these occur at the home. So absolutely, if you are a landlord and you're allowing a tenant to have a trampoline on the property, you have a risk of injury, especially if they have anybody between the ages of 5 and 15. And here's another thing to consider. It's not just the occupants who are at risk. You've got neighbors, you've got friends that come on over. If you've got parents who aren't carefully watching what's going on, you have the threat of a claim that comes against you as the property owner. And we're going to talk a little more about liability throughout, but liability is absolutely something you have to take under consideration. How much liability am I likely to be subject to because I allowed my tenant to have this trampoline? Or again, you don't even have to affirmatively allow it. If you don't prevent it once you know about it, you have the risk of potential liability. So, well, what if instead of there being a strict prohibition in your lease to a trampoline, what if instead your lease is 100% silent on the issue of trampolines specifically? Well, you're going to want to know absolutely what your trampolines, you're going to want to know what your lease says about trampolines. And if your lease doesn't expressly prohibit them, then is there some other element in your lease that you can use to point to the tenant in some way creating an unreasonably dangerous situation? If your tenant and you are kind of on the fence and you're being asked for permission, the lease doesn't point blank prohibit it. There's maybe some language that you could use to prohibit it, but it's not explicit. And the tenant is going out of their way to ask your permission. You got to ask yourself a series of questions. And here's where the issue of liability comes in. Number one, If your lease is silent on it, what does your insurance say? Your insurance may already say, nope, not going to happen. An injury with a trampoline is not covered under this policy. And so if you allow a trampoline on this premises, you're on the hook 100% for any claims that might derive from that injury. Second, does the tenant have insurance to properly cover any claims that might occur from them using a trampoline on the property? So this isn't you necessarily as part of the equation. If instead your tenant is properly insured, then maybe it's a consideration that you could have, but I don't know. This is between you and that tenant, whether or not there is suitable insurance to cover any such claims. Next, you can't rely on the pure oral agreement from your tenant to take care of everything if something goes wrong. That's just not enough. You can't take that oral agreement into a court and say, well, they said they would handle it if something went wrong. Instead, you absolutely have to have it in writing because your lease is in writing and you want your protection to also be in some written format. In one instance, it's your lease that prohibits the use of a trampoline. But if you're asked permission, I would always send my response in writing and say, I understand that you've requested permission to have a trampoline. I've reviewed my insurance coverage, and a trampoline would not be something that I can allow based on the limits of my insurance coverage. So I'm denying your request to put a trampoline on the property. If you've already put up a trampoline, please have it removed within the next 24 to 48 hours. Put that in writing so that it's crystal clear in the event that in the future you have to have that communication reviewed by a court. And then finally, if the tenant refuses to remove the trampoline or brings it back later, you absolutely have to issue a notice to vacate. Again, if the thing hadn't come up and your lease is not explicit and they put up a trampoline even without asking, it may be a toss-up whether or not it is an actual violation of the lease. But if you've given them notice and told them, please take it down, there's language in here that allows me to prevent you from having it, please take it down. They say, okay, no problem. They take it down, and then a couple weeks later, the kids pop it back up, or the parents allow them to pop it back up, and at that point, you got to start issuing notices of default. And if it continues, you ultimately will have to issue a notice to vacate. You have to take these things seriously, especially with the number of injuries that could potentially occur on your property from the use of a trampoline. There's too much risk for you just to let them off with a verbal warning or to just turn a blind eye. That's when you're going to get hit with a huge bill when some kid from the neighborhood comes over, jumps a couple of times, lands on the pavement, breaks his neck, and now you're on the hook as the owner of that property. So don't open yourself up to risk like that. If you can prevent it, make sure you do it from the get-go and that your lease prohibits trampolines on the property. If there's a trampoline later and you can prohibit it based on the terms of your lease, send notice to your tenant. If they refuse to take it down or put it back up after, send another notice. And ultimately, if you can't convince them to do it right after notice, after notice, after notice, notice to vacate, say that's it. You're paying the rent, but this liability is too high. We got to cut ties. So, all right, we've got Tanya Seaman. What about a signed release of liability? Well, here's the thing. In a lot of leases, you've already got that. You've got an indemnity clause where the tenant agrees that if they do anything, they'll assume the responsibility. The problem is that's a contract between you and your tenant. A third party who is injured isn't going to care about that indemnity agreement. They're going to come after you. And the truth is, if your tenant doesn't have the capacity to cover any claims, you're ultimately going to get hit, or your insurance company is ultimately going to get hit with this claim, and then you're suffering the consequence of possibly higher rates or denial of future coverage or other complications that might arise from that liability. the idea that they're willing to sign a piece of paper probably isn't enough, especially if they already signed a piece of paper that said they were never allowed to have a trampoline in the first place. So I'm not in favor of liability waivers in this kind of situation because there's still too much risk. There's the risk that the tenant can't cover you, can't actually indemnify you, and that the injured party comes after you anyway. VGentry83 says, I always put it off on the insurance company. I tell them that my insurance company doesn't allow it. And that's a good strategy. It's one of those things that makes somebody else the bad guy. You say, look, the decision's out of my hands, but I got to follow what my insurance company says. And so that's why I'm denying it. It's not because I'm some Grinch. It's not because I'm some big evil landlord who hates, the enjoyment of children. It's because it's strictly an issue of liability. And when it's when it's denied by your insurance company, that's a serious thing that your tenant should also take seriously. Okay, thank you guys for your contributions. I'm going to jump into the questions from earlier this week that, again, I didn't get to because I was in trial all day on Wednesday. But I appreciate those of you who showed up today on Friday to participate in this live. A lot of you are going to watch us in the replay, but many of you are used to joining us on Wednesday afternoons. And we'll be back next Wednesday at 4 o'clock for our next YouTube live. But here we go. Jonathan asks, hey, Ernie, my question is about assessing late fees. I have a landlord trying to add late fees to a tenant's account. Here's a snippet of the lease. The tenant was paying late each month for the past 12 months. That's already just a bad sign. If they're paying 12 months in a row late, this is something that should have been happening. This is something that should have been dealt with 12 months ago, but we move on. The landlord was accepting partial payments. Another problem. And was sending invoices that did not include the late fees. In February of 2025, the landlord sent an email stating she would start applying late fees to the tenant's account. In March 2025, the invoice did not include late fees, but the tenant was behind on rent. The tenant asked the landlord for a balance due and the tenant paid it. The balance did not include late fees. And this is a common thing where if your balance sheet doesn't reflect reality, you can't expect the court to bail you out. You need to be on top of your own ledger. You need to be applying payments to the oldest debt first. That's that classic statement that I make all the time with landlords. Do you have an application of funds clause? Utilize it. Apply the entire payment that you get to the oldest debt first, and you're always going to be better off. Let's continue. The landlord now wants the tenant to move out so she can place another tenant in the home. Tenant refuses to move out because the lease has not expired. Now the landlord wants to charge late fees dating back 1 year. Can the landlord charge late fees dating back a year, even though they both agreed the account was current? I've told the landlord this feels like retaliation, and though they both agreed the account, I've told the landlord this feels like retaliation and bullying. I also told the landlord she cannot retroactively charge late fees, and they both agreed the account was current in March. I'd love to hear your thoughts on this. Well, yeah, remember, when you've got a written lease, the only thing that can modify that written lease is an agreement by the parties in writing. I haven't reviewed any of this. I'm just hearing this anecdotally, but it sounds like you've got a modification of the balance owed between the parties that is recorded. That written instrument could serve as a modification. It's kind of like when you get a receipt that says paid in full. Sometimes that means you paid 100% of the balance owed, and sometimes it means you paid enough that the merchant feels satisfied with what was paid and marks the whole thing paid in full. If that occurred here, you can't do backseas. You can't say, oh, well, now I'm going to charge you again when I refused to charge you the last time and then marked it paid in full. That's not the way the law works. If you regard payment in full at a certain point, you cannot then undo that and expect the court to bail you out. This is just, it's not good practice, and it's likely going to result in frustration. Your better bet is to maintain a better ledger. Apply your payments better throughout the year, and you're not going to have these problems. If it turns out that a tenant pays late or pays partially, you're issuing notices. You're issuing notices of non-payment. You're issuing notices of default. You're issuing a notice to vacate and resolving your matter that way. If you're not doing any of those things, and then you're kind of doing silly stuff like this, declaring a debt paid in full and then trying to undeclare it, that's when courts get very frustrated with landlords. So no, I don't advise this practice, and I wouldn't be able to sign off and say, yeah, that's a good idea. I'd take that case in front of a judge. Larry asks, what is your interpretation of the CARES Act requirement of 30-day notice to vacate for covered properties, Fannie and Freddie loans, and Section 8 tenants in Texas? I've been told by some that you should absolutely give 30-day notice in those circumstances, as even if you win in JP, it could be overruled if the tenant appeals. Others say if the JP only requires 3-day notice, go only by what the JP requires. Is there any definitive answer from the courts in Texas? Any actual cases that have been tried? Oh, have I tried cases like this in the past? Yes. Now, let's talk statistics. Most JP evictions never get appealed. And of the ones that do, about half of those make it to trial. So I tend to tell landlords about 80% of cases start and stop in the justice court. So that 20% go, and about half of those, so you're talking about 10% of cases that actually make it in front of the county court judge. And a lot of those cases, just like in the JP, are one, uncontested. The tenant just doesn't show up. The whole thing was just about delay. So these issues on appeal can come up, which is why it's important to get it right from the beginning, but often don't, because it's a matter of procedure that most tenants don't know how to raise. That's not the same thing as it's okay to simply not follow the law. The law is explicit. It is correct. It is in black and white as it is. If you're leasing to a Section 8 housing, or you have a federally backed loan, whether that's a multifamily federally backed loan or a single family federally backed loan, you must give a 30-day notice. In fact, I recently did a video on this exact topic, which I released this last Monday. I suggest you check it out. It talks all about the CARES Act and whether or not you are subject to that 30-day notice. I go more in depth in this question, and my response will go. So I strongly suggest you guys go check that out if you've got questions about the 30-day notice. But yeah, there are some JPs that don't regard the CARES Act as still substantive law. There are many that regard it quite highly, but that's not the point. The point is, what does the law say? And you should always follow the law for a couple of reasons. Number one, JPs change. Number two, JPs get sick. And sometimes you walk into a court where you think, well, this JP always goes this way, but the JP's sick that day and they've got a visiting judge who happens to always go this way. And guess what? That's when you get hit with a dismissal because you didn't do the right thing when you were supposed to have. So if you're always following the law, you're always going to avail yourself to the benefits of what the law allows. And so, yeah, I don't like the rule of, well, as long as the JP will let it slide, you're going to be fine at county court, because that's just not true. And different courts are going to handle things differently. But definitely, if a tenant hires counsel and they figure this out, they're going to raise that issue. And counsel can be hired for people who are indigent, people who don't have funds, and there are free attorneys out there who represent these people all the time, typically in more densely populated areas like Houston and Dallas and San Antonio and Austin. But they are all over the place. And so they could be in any Texas county, any county across the country. And so if there's an attorney there, I know if I were representing a tenant, that's one of the first places I would look, because procedural errors are the easiest ones to present to the court. It's in black and white. You should have done this, but you did something else, so you lose. You got to start the whole thing over. So, if the law requires it, follow the law. It's not worth having to start over, especially from the appeal position, because that could cost you easily 90 to 120 days. That's a lot of lost rent. Take the 30 days from the get-go and just do what you're supposed to do. You may actually find that within that 30-day time frame of your original notice to vacate, that the tenant just leaves, that they seek to avoid getting an eviction judgment on their record, and you recover your property in about the same amount of time anyway, except now you're not paying court costs. So something to think about. Thank you, Larry. Let's see. Mr. B says, I just bought a multifamily house and the tenant is month to month and she has 4 cameras on the property. Can I remove them in Connecticut? Well, Mr. B, I don't know what Connecticut law says, but typically, if you are the owner of the property now, you can do virtually whatever you want with your own property. The general rule is that once an item is affixed to the property, it becomes part of the property. So it's no longer, excuse me, it's no longer the property of the tenant. So if the tenant, for example, installed a ceiling fan, well, guess what? That's a fixture that now belongs to the property, even if they paid for it, even if they paid to install it. Now, if you have a written agreement that says you may install and remove these things at your own cost, that's a slightly different scenario. But if they simply installed the item with or without your permission and did not have a written expectation that they can retrieve it, that belongs to the property now. And so my guess is the same is true in Connecticut. And because those cameras belong to you, the now homeowner, you can remove them. However, there's a possibility that you're going to create some kind of issue with the current tenant. If that tenant is in fact on a month-to-month, I would seek to terminate. Once that tenant is gone, then you can remove the cameras and do whatever. If the tenant seeks to take the cameras with them and you don't mind, then feel free to allow them to do that, as long as they don't cause damage to the property. I hope that helps. Now, as you hopefully know, I'm not licensed in the state of Connecticut. I'm licensed in the state of Texas. So my legal experience and my legal advice would be limited to matters pertaining to Texas law. So, all right, Go for Rent says, thanks for the update. You are very welcome. Let us continue. Cindy asks, how do I read credit reports? Tips and tricks on what I'm looking for. Well, so it depends what all is in the report you're looking at. I'm not sure what you're looking at, but you're going to want a benchmark, and everybody has different benchmarks, right? Some people will accept somebody with a 600 credit rating. Other people will not. If you're only accepting people with an 800 credit rating, you're going to limit the pool of people who are available to rent your particular unit. And so, what kinds of things might be in a report? A report will likely tell you, number one, their credit rating or their credit score, but a report might also have things like old debts. If they have various amounts of debt that are currently, in arrears, that's a high indication that this individual does not manage their money well. And if they have current accounts that are in default, you can pretty well guarantee that your rent is going to be in default pretty soon. So, one thing you look out for is for current debt that is in default. That's just not a good sign. Somebody who can't manage their money well generally can't pay their rent in a timely manner. So, something for you to think about. Van Dale asks, I saw your Facebook post on do you allow credit scores under 700? I do, but my question is, can it depend on the class of the property? If I have a property located in Class A neighborhood, can the qualifications to rent that property, credit score, income be different than property located in a Class D neighborhood? In my experience, though it is possible, can you really expect someone who is renting the Class D neighborhood to have the best credit and meet the higher income requirements? Is this really realistic? I just want to make sure I'm not getting into any fair housing issues? Well, one way to avoid these issues is also with regard to the income requirement. And so typically, if you're leasing in a D neighborhood, the rent is going to be lower than what you classify as an A neighborhood. And so the income requirement should also be multiplied by the factor of that proportionate difference. So yeah, you can have a different or a range of what is acceptable, but understand that the credit score only tells you so much. But at a certain point, it tells you enough that the person themselves, whether they make $50,000 a year or $500,000 a year, people are bad with money on all levels, socioeconomically speaking. And so sometimes that score, even if you make a higher income, reflects whether or not you're any good with the money you do get. So you take some of this with a grain of salt. And none of this is 100% universal. But yeah, you can have a range of credit scores that you accept in certain situations. But make sure you are consistent within those situations. All right. V Gentry says, that's my question. Well, I hope I answered it well. Cindy asks, what steps do I take if a tenant argues the deductions from their security deposit? What do you tell them when they reach out? Well, so Cindy, your easiest, Cindy, I've got a couple questions from you. I'm hoping these are yours. If you just got here, though, there's going to be a replay, so don't worry. But right now, I'm on a Cindy question, so hopefully this is you. What steps do you take if a tenant argues deductions from the security deposit? Your best bet is what I call red light, yellow light, green light deductions. And this is how they work. There are certain things you absolutely cannot charge to the tenant. Things that go wrong from normal use and ordinary wear and tear. If a storm comes and breaks windows and puts holes in your roof, that's not on your tenant. It doesn't matter how terrible a tenant they are, they didn't cause that storm. That's ordinary wear and tear. Weather damage is ordinary and cannot be charged to the tenant. So that would be a very red light cost. Never, never, never can you charge these things to the tenant. Now, the yellow lights, these are the things that are a toss-up. They're a 50-50 jump ball. Maybe the tenant did it, but maybe not. So let's say you've got a cabinet door that all of it just came right off its hinges. Now, these are nothing new as cabinets. And the tenant says, I was opening the door and the cabinet door simply fell off. And sure enough, you take a look at it and yeah, the wood's not great. And yeah, it is pretty old. And it was a little wobbly before. But was it a matter of the tenant yanking the door right off? Or was it a matter of over time, weak wood, heavy door, it just broke? If you can't prove that your tenant, through misuse or negligence, caused the damage, I just don't think it's worth the trouble charging them for it. If it's a jump ball, it's just as risky that you lose and you're accused of wrongfully withholding or inappropriately deducting amounts from the security deposit than it is that you will be able to. So I tend to stay away from those as much as you can and instead focus on the green, bright green. You definitely can charge them because you can definitely prove misuse or negligence. If the tenant, for example, set fire to the kitchen wall and caused extensive damage, if they punched holes in the sheetrock and caused extensive damage. Not the same as they hung a few nails to put pictures of the family up on the wall. That's different than when the doorknob goes straight through the wall. So if you've got enough bright green deductions to take up the whole security deposit, you can throw in the jump balls, you can throw in those yellow light deductions. Never throw in the red light, the absolute, you're never gonna get money for those because there's no way the tenant is culpable for those. Always leave those out. But the yellow lights, again, if you've already surpassed the deduction amount, particularly if they owe you a full month of rent or something, enormous like that, yeah, you can throw those in there. But if you've only got a couple green lights and you don't have many deductions, I wouldn't rely too heavily on those so-so. I'm going to have a hard time proving these deductions to a court. And so your best defense is knowing when you've absolutely got bright green deductions every time. That's always going to make for the best deductions. If you are relying on any of these iffy ones, that might be where you have wiggle room. So let's say you've got $400 in absolute rock solid deductions, and you've got $1,000 on deposit. So you've got 400 absolute, no doubt, you can charge that. But then you've got another 400 that are, and you're prepared to issue a $200 refund. 400 absolute, 400, and then 200 definitely you don't have a claim for. And you send the 200 and the tenant goes, hey, look, I didn't cause X, Y, and Z. You've got about $400 worth of wiggle room there. And I would say don't be afraid to negotiate. You might just split the baby with those yellow light ones, the ones that are going to be 50-50 jump ball. It's not worth taking those to court. So if they'll accept half of that money back and say, look, I'll send you another 200, will that resolve the matter? If it does, get it in writing and you're done. Otherwise, you might be better off just sending the full $600, keeping only the bright green $400 deduction, and avoid a whole claim, avoid having to go to the court, having to present a defense, having to make your case that you made a proper deduction, and avoid the possibility of losing at court. So I hope that helps with the deposit. Tanya has two questions. And Luciano Hinojosa says, that's why I take a lot of pictures. Yeah, it's essential that you document the condition of the unit before anybody comes in, and then you immediately document the condition of the unit once they've moved out. You need to be on top of what you can prove is the difference before and after the tenancy. All right, so Tanya says, I have two questions. Number one, are you familiar with the basic Zillow lease? Have I made a mistake? The tenants are a pain. I've read the Zillow lease. I can't say that I've committed it to memory. The thing about these kind of national companies is sometimes their leases are a little bit generic, but for the most part, they're going to get the lease right. I would need to know more about what's causing you pain to be able to tell you whether that lease has real teeth. But generally speaking, these national leases aren't going to get into the nitty-gritty, very specific Texas stuff. But for the most part, they're going to keep you covered. And so I would need to know just a little bit more about what you're saying. And then I would need your Zillow lease in front of me because I don't know if any modifications have been made or that special provision section has been filled with all sorts of goodies, which end up ruining perfectly good leases all the time. So for the most part, yeah, your Zillow lease is going to be okay. It's not my favorite. But neither are any of the kind of the national leases out there. Your Office Depot lease, terrible. So limited and just way too generic to be Texas specific. So if you're talking about state specific, I would stay away from some of the more national kind of stuff. Question 2, tenants wanted to pay rent by cash. So it was written into the lease without instructions of how or where it would be collected. That's a problem. They quit meeting me at the usual time and place and are making it difficult to collect now. Can I amend the type of payment without their consent? So here's where that creative tweaking of the lease comes into play, because if you agree to accept cash payments and they are tendering cash payments within the bounds of that agreement, I don't know what making it difficult means. But if your terms are ambiguous and can be interpreted in multiple ways, what the law tends to say is, listen, they didn't draft this lease. If you drafted this lease and allowed this change, then whatever the ambiguity is, it's going to be resolved in favor of the non-drafting party, which is typically the tenant. And so if the lease allows the tenant to say, hey, I've got this here, you got to come to my house, or I'm available on Thursdays. So the lease says when available, you kind of back yourself into a corner there. I don't know the specific terms of your lease and whether there is that wiggle room, but the fact that they're being difficult doesn't mean they're out of compliance with the terms of the lease. So I would, maybe take a hard look. Can you change it? I don't know what your lease says about that. Probably not. That's probably something you're stuck with, unless they are genuinely in breach. If they're genuinely in breach, issue a notice to vacate for non-payment of rent, and then you don't have to worry about modification. Just get rid of them, or prior to getting rid of them, say, look, I'll keep you as tenants, but we got to modify this provision. And if they'll sign a modification at that point, then maybe you can undo it. But until they're in some kind of substantial breach, you're kind of stuck. And so again, this is why I don't like the kind of the cute modifications of leases, and I don't like cash payment. I think it's a bad idea. I've done videos on that before. Cash is just complicated. I got another question from Cindy, and Cindy says, V. Gentry said pretty strongly, Zillow lease sucks. If that's your opinion, I don't know that I would go that far. But yeah, you are entitled to that opinion. Again, it's basic. It's basic because it's trying to be universal. Cindy says, Luciano, for green light items, how do you answer to the tenant questioning or trying to say they don't agree, even though it was explained in the itemized letter? Have you experienced that? So I don't know if this is going to Luciano or meant for me. I'm happy to answer it. They don't have to agree. The issue is, can you prove 100% that these are right? And so if you've got 100% proof, I wouldn't worry too much with what they agree with or not. If you've got 100% proof that they owe you 100% of the security deposit, you're done. It's not up to you to prove it. So if they owe you, for example, a whole month of rent and then $400 worth of damage and the security deposit was 1 month's rent, you're done. Right? If you can prove they owe you the rent and the damage, they owe you over and above the security deposit. So again, it doesn't matter what they agree with. Tanya Seaman says, they changed the time and is now very difficult for me to meet them. Yeah, that can come up, Tanya. And so I don't know if the time was specific in the lease. If the time was specific in the lease, you can enforce that. And if, for example, if it says they'll pay you at the property at 5 p.m. and you show up at 5 p.m. and they're not there, issue a notice. That's a notice of default, right? Because the lease said this way and they want to do it some other way. Nope. If you're there to enforce the provision and they say, no, we can't do that, then you say, well, if you can't, then you can't stay because you are in default. And if you're in serial default of the lease, then you got to find a different way to pay, because the only option to pay in cash is to meet me at this hour at this place, because that's what the lease says. So I would rely on what the lease says. Again, if it's ambiguous, that's going to create problems. So Leilani asks, what are clauses to always have in your lease agreement, as I have been only using the standard lease agreement on Avail? Also, the policy around support animals and how to go if there is damage on the property from them, as I've read you can't charge for them. So since we're talking about lease construction and these kind of national groups, if you've got a lease from a national group like Avail, I'm not super familiar with that. I'm not familiar with it at all. So I can't tell you what it's missing. I can tell you that it's important for you to have a lease that is, in line with Texas law. And if you don't see anything about the state of Texas in that lease, that's your first red flag that it may not line up perfectly with Texas law. Security deposits are common. Repair issues are common as kind of key points where the lease should address state law. And if you're in Texas and you're using a lease, it doesn't refer to the state of Texas in any way, you've probably got a generic lease that probably doesn't protect you to the maximum that a better lease would. Now, as far as emotional support animals, there is a myth out there that an emotional support animal can come onto the property and just tear things up. That's not true. Think of the emotional support animal like a medical device. And so you can't treat it like a pet, but let's say that medical device was not well maintained by the owner, or was not properly used by the owner, or somehow blew up and caused damage to your property, right? Let me give you an easy example. Somebody has an oxygen tank. That's not a pet. It's a medical device. They have an oxygen tank that they use because they have trouble breathing. But they also smoke, right? And they're smoking by that oxygen tank, and boom, they blow up the garage. And probably themselves, but for purposes of this illustration, all that happened was that the garage got destroyed. Can they say, well, I was allowed to have the medical device? No, they cause damage to your property. And even an emotional support animal, if they cause damage to your property, that's a breach. The fact of the animal is not the breach. The damage to the property is. Issue notice, issue repair bills, get stuff repaired, and if they fail to stop the animal from future damage, if they fail to pay for the damages that were caused by the emotional support animal, then that's a reason to get rid of them. Again, it's not the animal itself that's the problem. It's the owner of the animal failing to keep that emotional support animal in check. If their emotional support animal is causing damage, you have every right to issue them notice for that damage and to charge them for the repairs. That's not normal use. That's not ordinary wear and tear. And if you can't collect a security deposit, it's incumbent on you to hold them to those repairs as they occur. That animal damages something immediately. You're in there, you're saying, I'm gonna get this repaired. I'm gonna have my guy come in and fix this. If this happens again, and here's your first notice of default, I'm gonna issue another one, and whenever this repair is complete, I'm issuing a bill. You're going to have 7 days to pay it. Now, this should be very clear to your tenant, and it should be enforced immediately upon you finding damage to your property from an emotional support animal. Let's get to some of these messages. Tanya says, thank you so much. You are very welcome. Tanya. James says, hello. Hello, James. Good to see you again. Tiger Harris says, at end of a commercial lease, holdover says tenant becomes at will, but landlord continues to accept rent. Does lease become month to month? Yes, it does. It becomes month to month by operation of the parties. And so the fact that you had an at-will tenancy, it transformed, and now it is a month-to-month tenancy because the landlord accepted rent. Now, can that easily be terminated? Yes, but you got to send proper notice. James goes on to say, if a tenant surrenders, hands over the keys, an apartment with their items left in the apartment, what do you do with these items? Well, first, look to your lease, James. Does your lease have an abandonment clause in it? An abandonment usually happens when the tenant has left in your reasonable estimation, and here, if they've turned in the keys, they're gone. If they owe you at least 1 month's rent, so if they've left and now a new rental period has begun and their stuff's still here, they owe you rent. And then number 3, you've given them notice. And typically the abandonment clause in your lease sets out this procedure, if you have one. If you don't have an abandonment clause, but these factors play in, they're gone, they owe you rent because their stuff stayed behind, and now there's a new rent period started, then the last thing is to give them a reasonable notice. So, and this is why notice is important. You've got work email, personal email, text, maybe a tenant portal, all sorts of ways to get a hold of your tenant. And you say, look, you left your stuff behind. I am assuming this stuff is abandoned and is otherwise garbage, but I'm going to give you 48 hours or 72 hours to come and get your stuff. If you fail to do that, upon my assumption that this personal property is abandoned, I will discard your personal property. again, your lease really should have an abandonment provision in it for these occasions. In fact, good leases in Texas will allow you to put that notice on the inside of the main entry door, close it, wait 48 hours, and then you come back. If they have not taken their stuff or made some kind of arrangement with you that you find reasonable, then you can go in there, clear out the unit, throw everything away, and re-let the property. That's my advice. Always, always, always give them adequate notice, give them a reasonable amount of time to come and get their stuff. If they don't, toss it. Cindy writes, can I fire my realtor? I couldn't find anything about our contract about terms around that. Well, just because you didn't find it doesn't mean it's not in there. I don't know what your listing agreement says about firing your realtor. I don't know what you signed. It's possible, sure, but you don't want to be in breach because just like you and your tenant sign an extended term, you may have signed an extended term with your realtor. Again, I don't know exactly what your agreement says. Definitely you can fire them for cause, but I don't know what the cause would be in this situation. If you have a written agreement, refer to that agreement. If you're unsure what you're reading and whether, or you're unsure whether there is a provision in there that can help you, seek out legal counsel. That's the best advice I can give. James writes, what would that include an inoperable car left in the driveway? Yes, it would. And so if you're in the city of Houston, for example, this is a common thing where people just leave junk cars. Again, same notice, give them a reasonable opportunity to come and get it, and then you can call the city of Houston to have them towed away. Because yes, it's an abandoned vehicle, and there's a specific procedure in the city of Houston and in many cities and states for collecting abandoned vehicles. James, you're welcome. Tiger Harris writes, what does a landlord do if the tenant leaves an abandoned vehicle? Well, there you go, 2 for 1. Again, notice and then follow the procedure for your city or your county. All right, here we have a question from a realtor. My question is about assessing late fees. I have a landlord trying to add late fees to a tenant's account. Oh, you know what? I already answered this question. Yep, answered it. So now we go back to Tanya. Tenants recorded me talking to pest control company without being there and complained to me about what I said. I think this is a violation. What recourse do I have? Their excuse is they have cameras because they have small children. Well, an individual can have cameras on the inside of their own property at all times. You, the landlord, can't control with a camera what you see inside their property. You can control what's outside of your property, not inside. So if they have their own nanny cam or whatever, and they, caught you saying something, I mean, it would be the same as if you were there. You don't have a right to privacy in their home. And before you get too upset with me, for purposes of this tenancy, it is their home at that time. And so, yes, they do have the right to record whatever they want without your permission even, while they are the tenants of that property, if it's inside the house. Once it's outside, anything that's open air, again, subject to recording, there's no privacy expected, out in public. So in private, they can record themselves, and if you happen to be in the stream of the recording, they can keep that. Now, I don't know what you said, and so if you said something defamatory, they could potentially hold that against you. I can't imagine what you told the pest control company, except maybe if you had negative opinions about why there were pets on the property. It's not defamatory if it's true, and if they've got food lying around, or they've got moisture, or they've got other things that contribute to pests, then again, I wouldn't worry too much. But if there was something defamatory said, you might have some liability. I don't know. Probably not, though. So I would need more facts to be able to address this specifically. Oh, I see. You just said the house was dirty, drags tracked mud in. Again, these are facts that are provable. They're not your opinions, and therefore it's not defamation if the fact is true. I mean, yeah, if you said, oh, they left the door open or they left the window open and rain came in. Yeah. Now, if you said, I don't know, if you made something up, like, oh, I know that they brought pests with them, or they had rats in their boxes or roaches in their boxes when they came in, and that's 100% not true, then maybe that's defamatory. I don't know what kind of damages they would have from that. It's very silly, actually, this whole idea. But I don't think the statements that you said are in any way consequential. Cindy writes, when we enter for inspections, can we take pictures? This is a good question. You can take pictures of your property. I would stay away from taking pictures of their property. You want to take a picture of the toilet? Go ahead. You want to take a picture of the ceiling? Go ahead. You want to take a picture of the kitchen appliances? Go ahead. Don't go through their personal stuff, and don't go taking pictures of them, especially if they're not interested in being photographed. Take pictures of your stuff, your appliances, your wall, your floor, your ceiling. That all is okay. Once you start taking pictures of their stuff, probably not a great idea. But yes, you can document and photograph the condition of your house. Cindy goes on, my realtor took videos of the messy house while she was showing the house while the house was occupied. Again, you could say you were videoing the floor or the walls or the ceiling and this stuff happened to be there. That's different than going into a bedroom, for example, and opening drawers and taking pictures of what's in drawers. I've seen landlords do things like that. Not a good idea at all. Courts never like that. But if you are, documenting the condition of the property, that could include things like, well, what does the floor look like? What do the rooms look like? Especially if you're documenting things like, the failure to maintain the property in good working order or in a sanitary condition. So that was the last of my questions. I don't see any more jumping on the chat here. I hope this was helpful to all of you who stayed on through the end. Next week we have another topic. I'll share that with you. This one's going to be on Wednesday of next week. Hopefully I'm not in trial. I shouldn't be. I don't have anything scheduled. Is it safe to lease residential rental property to a business? Is that a good idea? I've got thoughts on that. I'd like to see your questions on the topic. And until next time, landlords, as always, I hope that things are going well for you. You have a great weekend. And until next time, happy leasing. You're very welcome. All of you who said thanks. Take care.